file 25-9099. Counsel, you want to state your appearances, beginning with the plaintiff.
Your Honor, Dr. Schaefer here on behalf of the plaintiff, Robert Kramer.
And Mr. Martin is here for defense, Mr. McGinnis.
All right, buckle up, because we're diving straight into a courtroom battle over legal fees. The defense already got the case tossed, and now they want the plaintiff to pay up. Translation? You wasted our time, now pay for it. Let's see how this plays out.
And Mr. Martin, I had previously granted the defense motion for summary disposition, and defendant has now filed a motion for costs and fees. I've reviewed the motion and the response. Mr. Martin, go ahead.
Thank you. Defendant moves for recovery of attorney fees as set forth in the text affidavit to our motion. The basis is that this was a complaint that should never have been brought, lacking factual evidence and not doing a thorough legal examination of the theories. Evidence, as the court may recall, is that they filed a count that was far exceeded the statute of limitations. Their claims for the publishing failed to assert or allege that they requested a retraction. It's required by statute. The citations in the plaintiff's complaint were skewed and misrepresented to the court as complete and accurate. They were not. We showed that at the summary disposition hearing. And in addition, plaintiffs missed all deadlines and initial disclosure, witness exhibit list, and all that. This was done nothing for harassment. This was protected political speech, as the court noted time and again. It was done for harassment purposes.
Did you catch that? This was done for harassment. The defense just pulled out the big guns, accusing the plaintiff of weaponizing the courtroom to settle a score. That's a bold claim. But is it legally sound? Let's keep watching.
We ask the court to grant our relief.
Thank you, Mr. Martin. Ms. Schaefer?
Yes, Your Honor. I'm sure the court is aware there are three possibilities for a frivolous complaint. One that is brought to solely to harass, embarrass, or injure the other party, or that the person who brought it had absolutely no reasonable basis for believing the factual allegations, or that...
Here comes a crash course in what makes a lawsuit frivolous. 3 strict standards. If the case was meant to harass, based on nonsense, or built on baseless law, then it's game over. But Ms. Schaefer isn't folding just yet.
There was no legal, possible meritorious legal argument. And this request for attorney fees and cost fails on all 3. In terms of any request or any intent on the part of the plaintiff, Mr. Kramer, to harass, embarrass, or injure Mr. McGinnis, I do believe the affidavits of 20 witnesses, 20 members of the community who have actually witnessed the meetings, witnessed Mr. McGinnis's behavior, witnessed his statements, witnessed his physical attack on the Mr. Kramer and other board members. All of those affidavits, I think, speak volumes as to the fact that this is not a situation of Mr. Kramer in any way, shape, or form trying to embarrass, harass, or injure Mr. McGinnis. It is exactly the opposite. Mr. McGinnis is the one who has engaged in a sustained campaign for over 2 years of the intent to harass, embarrass, and injure the reputation of Mr. Kramer. As for whether or not...
Now things are heating up. The plaintiff's attorney flips the script, accusing the defendant of being the real aggressor, not just verbally but physically. If true, that adds serious weight to their side. But remember, this is a defamation case, not assault. Relevance? That's the judge's call.
Mr. Kramer had any basis to believe his factual allegations. Again, this isn't something where he just believed what he was saying. He has been backed up by these 20 witnesses to say this occurred. And I actually don't think there's much dispute as to the statements being made by Mr. McGinnis, it comes down to the intent and the interpretation and the context. And as we point out in our brief here, context is everything in every defamation case. Yelling fire is an entirely different matter, depending on whether you're standing outside a house that is burning and it is on fire, or whether you're standing in a theater and there is no fire. So the context and the circumstances mean absolutely everything. And in this case, I realized it was a rather unusual one. This is one that is not taking a single statement, looking at it and saying that that's it, that's the entire case. I would point the court to the most recent case on Mr. Moran, the Ironworks case. We're talking about there a single statement, made on the radio, and that being enough for someone to come into court and say, and it was, there's been some general statements made, people that say nothing more than this person has just stopped lying. He's been lying about a lot of things, and people sue over that. And it is, if it's not true and does injure that person's reputation, well, that's defamatory, and you can bring a complaint on it. In this instance, I think the court struggled with the way the complaint was stated, is that we did put them into individual counts. And that's because we do believe that, in fact, each statement itself is a matter of defamation. However, we fully agree with the court, too, that looking at them individually and not in context, you could say that, well, why would you bring a complaint over it? I believe that the court's reference was to, anyone who sits in a political office should grow a thicker skin. And that would, in past times, certainly that might be the way it goes. But I think we attached the article kind of detailing what things are happening now around the country, and not to, exaggerate, or make too big of a deal of it. This is, not quite the same situation, but that's a concern. That's what caused Mr. Kramer, and I think you can see from his wife, Nancy Kramer, and also other affidavits, people that were scared, people that were very, very concerned about these statements, the conduct, escalation, and what was happening. And that's the basis for bringing it in that context and looking at everything as a whole. And I would ask the court to remember that we didn't even get through discovery or even have an opportunity to depose Mr. McGinnis or his wife or anyone else. And so the ability to bring that forth, and also in a more full fashion, as well as the opportunity to amend the complaint if the court's concern is with stating them individually and it doesn't make the case
you've
there.
said that a lot, and that's not my concern at all. I mean,
okay.
I was asking you to justify some of them, and you couldn't. You simply couldn't. And at the summary disposition motion, where I said, well, why justify why I shouldn't grant summary disposition on count 3 or a specific count, and you couldn't. And I think that's proper line of questioning, but all of that put together, my still fundamental problem.
And there it is, the judge's razor-sharp focus. A citizen criticizing a public official, aka core First Amendment territory. This is where free speech gets real messy. The court isn't interested in name-calling or feelings. It's asking, were the words themselves legally defamatory?
This is a citizen standing at a public meeting during public comment and criticizing a public official for the performance of his public duties, which makes it different from any other cases I may have pending, which I'm not going to comment on. But commenting about a public official's performance or malfeasance or misfeasance or nonfeasance in the performance of their public duties is at the heart of the First Amendment. He's not standing there and saying, Mr. Kramer in his personal life is doing X, Y, Z, totally unconnected to his public service. Well, that may very well have been defamatory, but all of this was about his performance of public duties, wasn't it?
Each of the statements did in some fashion relate to something going on in public duties. I would not say that each statement made at the time had any relation to what was at issue in that meeting or what was in front of anyone, but in some way you could argue that it had some relation to what Mr. Kramer does in public life, particularly because Mr. Kramer's public life is not simply sitting at the board meetings. He also engages in many other community activities. And so things that Mr. McGinnis said may very well relate to conduct of Mr. Kramer that is in public. Your Honor, I have to say, when I've never seen anything like what we have here, where I said to Mr. Kramer at the last hearing, obviously we knew we had a reason to bring this. We certainly had no intent to harass or injure anyone. Firmly believe the factual basis, firmly believe that there is a meritorious legal argument to be made about the overall context of all of these statements together being defamation. But what I wanted to do was, have a kind of a double check. Let's ask other people. And Mr. Kramer asked people, you tell us, what have you seen? What did it cause you to feel? What did you think? What you saw? Did you see it as someone simply coming into a public, meeting and speaking about, public activities in a normal manner that anyone would want to protect as free
normal
speech?
manner? Normal. See, that's the thing. A lot of the affidavits, one of them called the plaintiff an angry leprechaun. I'm not sure why you thought attaching that is helpful to you, but that was impolite. But so was Mr. McGinnis's stuff impolite. So the normal manner thing. So whoever it was that called Mr. McGinnis the angry leprechaun, is that defamatory? No. Is it impolite?
Angry leprechaun made it into a court affidavit? Yikes. This case is starting to feel like a small-town grudge match dressed in legal robes. But again, the judge isn't here for playground insults. The key legal question remains, was it defamatory or just impolite?
Sure it is. And all of those affidavits were friends of your client or community members who say, we don't like the way Mr. McGinnis comports himself. And they described a situation at a meeting that they thought might have been an assault. Well, that wasn't what was pled in this case. This is a defamation case. So that was neither here nor there. So again, the manner that he's speaking it, unless he's disrupting a public meeting to where he's being removed, there's no requirement that the First Amendment be polite. I mean, there's protests, there's all sorts of things. So it's the substance of the statements. And I still am not hearing you even today explain to me why the substance of statements of a citizen criticizing a government official for the performance of his duties is actionable.
Your Honor, there is where I think the substance of the statements requires looking at the context in which they're made. And I do believe that is something that I think every defamation case, the United States Supreme Court, from starting with, New York Times versus Sullivan, says the context matters. And actually, I have to say that with regard to Mr. McGinnis not, acting out of order, he did. This is part of the problem, is that he did. The police report disturbing the peace. He had a deferred sentence on this. He was charged. They literally had to put into place having police at every meeting after that because of his conduct.
You sued him for what he said.
What's that?
You didn't sue him for what he did. You sued him for what he said.
I fully agree with that statement, Your Honor. My point is, again, any words must have context. You can't look at it in a vacuum in terms of, again, fire where there is a fire when you're standing in front of the building is different from fire screamed in a crowded theater. You have to look at the circumstances and the context rather than simply the words by themselves in a vacuum without any context at all. And in this situation, when you have someone who has disrupted meetings, who has attempted to physically assault board members, who has required people to bring in police at every meeting, who has then caused other people to fear for their safety at meetings, to stop going to public meetings so that they can have their right of free speech, because this person has been out of order so many times. When you look at it in that context and then say, okay, so now he is accusing Mr. Kramer of public corruption. He's accusing him of stealing from the Veterans Affairs Administration. These are, again, technical defamatory statements that can damage someone's reputation. They are not something that one single time someone making it in a public forum without any other instance ever occurring would go to court over, and we would not encourage that at all. But in this context, to say that simply because, and we understand the court's ruling, we certainly understand the summary disposition, and in that matter, that makes Mr. Martin and Mr. McGinnis the prevailing parties. But that does not in any way make them entitled to say that we have a frivolous claim where, again, we have not done anything to make this frivolous. This was brought with the legal argument that is viewed in context altogether over time as a campaign of defamation. Also, that the each individual statement can stand on its own as being technically defamatory, not such that someone should go in for a single statement. And the idea that Mr. Kramer is the one here who has done anything to try to embarrass or injure Mr. McGinnis, whereas, and again, I would speak to the affidavits. I would say to the court this: we did not ask anyone to write anything. We didn't tell anyone to write anything. We didn't edit because we wanted the people to be able to say and to swear to what they wanted this court to know. And so they did. And I understand, someone calls a name, a cartoon character name, the court is saying that's, so what, that's not an issue. And I would agree. But then it comes back to then why is it that, in Mr. Kramer's case, if he is repeatedly, again, in his words, attacked over every single thing he does, and in terms of crimes, then at what point does he ever get to say enough is enough? And again, I would say the context of this is looking at political violence now is a real concern, and it occurred in this case. And that's the context in which we brought this. That's the basis for it. I would ask the court to not find that this is in any way frivolous. Thank you.
Okay, do you have any other objections to the requested relief?
No, I cannot dispute his hourly rate or, yeah.
Mr. Martin, any rebuttal?
No, I don't think so.
All right, well, it's unusual for the court to order one side to pay the other.
Let's pause and talk about what the judge is about to do. Ordering one party to pay the other's attorney fees? That's rare. We're in English-ruled territory now, and in the US, that's usually reserved for truly frivolous lawsuits. If granted, it's a financial gut punch.
The other's attorney fees and costs. That's known as the English rule. The American rule is generally that each side bears its own freight. There are some statutory exceptions, and there's also an exception if a complaint is frivolous, which doesn't happen very often, as it shouldn't happen very often. The defendant says, well, in this case, the plaintiff's complaint was in fact frivolous. And frankly, I agree. As I said at the hearing where I granted summary disposition, this is not a hard case. This is core First Amendment protected speech. This is a citizen during public meetings, during public comment, criticizing a public official for the performance or non-performance or wrong performance of his public duties. Ms. Schaefer today sort of does a bait and switch and says, well, in the affidavits, there were other things other allegations or that were included that weren't part of the complaint. We're here today to not say what other things is Mr. Kramer unhappy about with Mr. McGinnis, or what other things are people in the community unhappy about with him. We're here to say, of the allegations that were in the complaint, were they frivolous? They were. I mean, it's surprising to me, Mr. Kramer filed it on his own. And then as Mr. McGinnis filed his answer, I think, on his own, and then lawyers got involved after the fact. I have to say, I'm a bit surprised that there's any lawyer that wouldn't have told Mr. Kramer, you ought to dismiss this case before you got to reach in your pocket here. And when I pushed Ms. Schaefer multiple times, explain to me what's defamatory about these statements, she just can't, other than saying it's the context and now trying to describe the manner in which Mr. McGinnis stated them or his behavior at a meeting. Again, that's not what he was sued for. What he was sued for was the content of his speech. And the content of his speech was a citizen criticizing a public official.
The judge doesn't just call this a weak case, he calls it not a hard case. That's brutal. He doubles down, labeling the complaint as clearly frivolous and even questions how any lawyer let it go this far. If you're the plaintiff, this is where you start sweating.
You can't get more First Amendment-y than that. This is, I think, quite clearly a claim that was brought without any legal merit whatsoever. It is, in fact, frivolous. I have reviewed, there's been no objections to Mr. Martin's proposed bill of costs. I did review it under the standards under Smith v. Curry and Pergo v. United States Auto Association. I did review the state bar's economic survey of the practice of law. And Mr. Martin's bill is a little bit north of the median, but it is a bit south of the 75th percentile. He's an experienced and skilled attorney in the community. This involved constitutional claims that he had to, for constitutional defenses, he had to research. So I do think that the hours and rate are reasonable. And looking at the factors to adjust them up and down, I saw no reason to adjust them either up or down. So the motion for costs and fees is granted in the amount claimed.
Final nail in the coffin, $9,415 in fees slapped onto the plaintiff. That's the price of pushing a weak claim into a courtroom. But beyond the bill, this case is a loud warning: free speech, especially political speech, gets heavy protection. And if you sue over it, you better come loaded with more than just feelings.
$9,415. Mr. Martin, you can submit an order.
Thank you.
Thank you. We're going to move into our family division docket for a bit, so terminate the live stream.